All right. Before we start with the actual program, I just want to take a brief minute to introduce for people online that we are here at William and Mary Law School in Williamsburg, Virginia, for a very timely, interesting, legally, politically, and personally, I guess, very important topic that I know we've all been paying attention to for quite a few months. In that connection, I think Professor Criddle and I would both especially like to thank Rob Bracknell, who teaches a course here in the International Law of NATO right now, and he will be teaching it again spring semester, another very timely topic too, and he's a great teacher. This 1 hour program is being co-sponsored by Professor Criddle's Center for International Law and Policy, my Center for Comparative Legal Studies and Post-Conflict Peace Building, and the Reeves Center for International Law from the main campus. And I would just like to take a minute to thank those who have contributed logistically and financially to make this particular program possible. Denise and Andrew Cook, in memory of Charles Cook, who was formerly on the faculty, passed away, was my own mentor, and the Reeves Center for International Studies. Both of them made this financially possible. Thank you, and I will turn this over now to Professor Criddle.
Great. Well, today, this week, we've marked the 1-year anniversary of President Trump's second inaugural. It seems like a good a moment to be thinking about the changing relationship of the United States with international law. And today we are going to discuss specifically the United States military actions involving Venezuela. So as you know, there have been an escalating series of episodes, beginning with strikes against alleged narco-terrorists in the Caribbean, then culminating in the abduction of President Nicolas Maduro from Caracas. And then today we seem to hear every day in the news that there are oil tankers that are being seized pursuant to a quarantine of the Venezuelan oil industry. And so there's a lot to sort through. Unfortunately, we're happy today to have two of the foremost experts on these topics here with us virtually, Professor Geoffrey Corn and Professor Ryan Goodman. Professor Corn is the George R. Killam Jr. Chair of Criminal Law and Director of the Center for Military Law and Policy at Texas Tech. Prior to his academic career, Professor Corn served as in the U.S. Army for 21 years, retiring in the rank of Lieutenant Colonel in the Judge Advocate Corps, where he served as the Army's Senior Law of War Advisor. Professor Goodman is the Ann and Joel Ehrenkrantz Professor of Law at NYU. He served as special counsel to the General Counsel of the Department of Defense, and no doubt many of you know him from his work as editor-in-chief of the national security website, Just Security. So we've invited Professor Corn and Professor Goodman to offer some opening remarks, kind of frame the questions for us today, and then we'll have some Q&A. So we'll hear first from Professor Goodman and then Professor Corn, and following their remarks, Professor Warren and I will invite your questions. Professor Goodman.
Great. Thank you so much just for the invitation to this event, and especially at this important time, and to be here with a friend and colleague, Professor Corn. And I'm very much looking forward to the conversation and the questions that are on people's minds. So I thought Professor Corn and I decided to divide this up in which I'll talk about the law with respect to the resort to the use of armed force, jus ad bellum, the UN Charter, and the like. And then Professor Corn will talk about, well, once in an armed conflict, or what might not be an armed conflict, what are the rules that apply? And so just to frame my part of the discussion, I think it's just important to say a couple things at the outset. So my presentation of my opening is going to be very much embedded in the existing law. And what I want to be explicit about is that there might be normative questions one might raise as to whether or not current international law is the best version of itself, in the sense that there are all sorts of rules that one might philosophically or normatively disagree with, such as, just to give one with respect to Maduro, should a legitimate head of state be respected, or do they have certain rights and prerogatives under international law? if the only real criterion for them having like head of state immunity and the like is just that they exercise effective control of their population. And international law opts in favor of no, they just need to exercise effective control of their population and their government. They do not have to have legitimacy and the like. And that's how international law operates. So I'm going to talk about whether or not U.S. operations are compliant with existing international law. There I'm bracketing that different people might have different views about how the international law rules should work, but these are the rules that states are the ones that have determined what they think the international legal system should be. And in part, I believe they have determined that on the basis of thinking that these are the rules of the road that are the best design for promoting international peace, for reducing the resort to aggressive wars and the like. So the first cornerstone international legal rule that it's just important to get out there to level set, which is the UN Charter, Article 2.4. So that's the big issue for the operations that the United States is conducting against both suspected drug cartel boats in the Caribbean, East Pacific, and then the Operation Absolute Resolve to apprehend Maduro and bring him to the United States to face criminal justice. So the UN Charter says, quote, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any manner inconsistent with the purposes of the United Nations. So that's the rule that basically says it is prohibited to use military force against another state. There are two exceptions. One, if there's Security Council authorization, and two, if the state is acting in self-defense against an armed attack. And those are the only exceptions. The conversation that I think we're having is operating at the international level, but we might also get into domestic law. And I think it's worth noting that the Senate ratified the UN Charter overwhelmingly 89-2, which is rare, 89-2. And we can talk about that if people have questions about the Office of Legal Counsel opinion that's now being published, in which the Office of Legal Counsel opinion seems to say, doesn't actually take a position. And I'll talk about that as to whether or not the Maduro operation was compliant with the UN Charter, but then says the UN Charter doesn't bind the president. And we can talk about that as a matter of domestic law. But it's mandatory. And the Senate understood that when they ratified it 89-2. I also just want to say, to set the context, there are several operations that this administration has engaged in that I think are compliant with the UN Charter and Article 2.4. The military operation in Nigeria, by all reports, it was by consent of the Nigerian state. There's a military operation in Syria. I think it's legally justified internationally and domestically because it was a continuation of the U.S. armed conflict against ISIS, or the Islamic State. Then there's a more controversial one where the United States government took an operation with the Israeli government to decimate, to some degree or another, the Iranian nuclear program. There, I think it's more debatable, and there are, in my view, good arguments on either side. So one argument is a piece that we published at Just Security by Amishai Cohen and Yuval Shani, which argues essentially that there's an ongoing armed attacks against the United States and Israel from Iran. And in the context of ongoing armed attacks, this is not like a strike in peacetime to prevent some state from developing weapons of mass destruction. It's during the context of these armed attacks. And that's the strongest argument in favor of it. And in fact, the United States submits a letter to the UN Security Council, which it's supposed to do when it takes these kinds of operations, saying that it's legally justified because the United States was acting in self-defense and collective self-defense with Israel against armed attacks coming from Iran. And that's important. I just want to underscore the United States submitted an Article 51 letter, is what we call it, because that's where self-defense comes from under the UN Charter, justifying its actions against Iran, because that's going to be very different from what's happening vis-a-vis Venezuela. So there are two sets of operations that I think we're talking about today. And the first one is the boat strikes, for an easy reference to it. So the boat strikes have been taking place since September 2nd. They are against apparently designated terrorist organizations that have been designated by the president and the executive branch. That includes Tren de Aragua primarily, and that Tren de Aragua, TDA, according to the executive branch, is engaging in attacks against the United States. The United States has in fact taken the position in one presentation before the UN Security Council that this was us acting in self-defense against these attacks. And I have to say the administration has been very inconsistent. It depends if they're in litigation in the Fifth Circuit or if they're at the UN Security Council as to whether or not they would say these attacks are being directed by the Maduro regime at the time or not, or have constituted a non-international armed conflict or not. They say very different things at different points. And I assume that Professor Corn will get into some of that. But one part of the boat strikes campaign that I think is important to note is many international lawyers have said that these are compliant with the UN Charter. And I think they're compliant with the UN Charter. I actually don't think they raise a UN Charter Article 2.4 issue. The reason is that the boat strikes are all taking place in the high seas. They have not taken place inside Venezuela. One footnote, there's a caveat of a reported CIA operation inside Venezuela against a port location. But aside from that one, they're all on the high seas and they're against stateless individuals. They're not against Venezuelan flag boats or something like that. And in those contexts, I don't actually think Article 51 applies, and that I've written and spoken about it previously and have said that it's not a UN Charter issue. It becomes a UN Charter issue once the United States, for example, starts using military force inside another state or inside Venezuela. And there are others who disagree with that, but I think the majority view, if I assess it correctly, is that it's not a UN Charter issue. That doesn't work when we talk about Operation Absolute Resolve, which is the operation sending in U.S. military forces into Venezuela, killing upwards of 75, 80 people in Venezuela, significant military strikes to apprehend Maduro and his wife and bring them back to the United States. What is remarkable about the military operation in Venezuela is essentially the United States has offered no legal justification under international law, has offered no legal justification under international law. And that's astonishing. I think that means that we're in a very new period. There have been other operations by the United States over time, Democratic, Republican administrations, where it can be debated as to whether or not they were legal, or one can conclude they were illegal. But almost always, the United States government stipulates that their position is that it's consistent with the UN Charter, almost always. We now have what was an internal document before the Office of Legal Counsel's December 23rd, 2025 opinion, which assesses under domestic law whether or not the operation was legal. But it first has a section on international law, and it doesn't actually say that it was legal. In fact, it is very ambiguous, ambivalent, and then it just lands on the idea that the President of the United States does not have to abide by international law, which I think is a highly controversial and wrong legal conclusion when it comes to the UN Charter ratified by 89, with support of 89 senators. But that's the domestic law question. I'm very happy to talk about it. I don't think that the OLC opinion is making that up. It was actually based on a 1989 OLC opinion, but I think that opinion doesn't withstand scrutiny, really. The Justice Department at the time, in fact, tried to keep it secret from both Congress and the public, partly because I think it could not withstand scrutiny. But what's so astonishing is the OLC opinion doesn't actually say that it was consistent with international law. Then the second part that's astonishing is that the United States government has not submitted an Article 51 letter to the UN. We have not submitted a letter like we did with the Iranian operation to explain why we believe that the operation was consistent with the UN Charter or compliant with Article 2.4 and Article 51. We just haven't. And an emergency meeting was called right after the operation inside Venezuela at the UN Security Council meeting. And astonishingly, the U.S. ambassador for the United States to the UN made no claim whatsoever in his remarks that the operation was consistent with international law. He didn't even say something that would be so easy to say in a certain sense, which is, oh, we were acting in self-defense, with this idea that, oh, Maduro is attacking the United States through the Tren de Aragua military operations and other drug cartels, and the United States administration considers that to be a form of an attack, which is a very serious stretch. Or another one that I was very much anticipating on the Saturday in which the operation took place, that the President of the United States would come to the podium and say, we, the United States, were operating inside Venezuela at the invitation of the legitimate government. They didn't say that. In fact, he said instead in that very press conference, we don't really consider the opposition leader to be somebody who even has support within the country. So he did not opt for that. What the U.S. ambassador said to the UN is just policy justifications that I think have no legal principle behind them and are certainly not limiting principles. One of the things he in fact said was that the United States could not tolerate one of the world's largest energy reserves being in the hands of our adversaries. If you just think about that, that language could easily be deployed by, and currently is being deployed by Russia with respect to Ukraine or Crimea, with China with respect to Taiwan. They can't tolerate certain important natural resources or the like being in the hands of adversaries. That's just not, there's no legal basis for that in international law for the use of military force. The one thing that the ambassador did say is that the operation is very similar to the U.S. operation in Panama in 1989. And there, I think it's a really important question. I think it's right of him to raise that because the U.S. position has been that that operation in 1989 was legal. So in some ways, that's a good move. That's a good debate to have. That's a good discussion to have. On the other hand, it's not the best forum to say that and just not go into the justification as to why it's legally the same as Panama. Why is that? Because when the United States intervened in Panama in 1989, it sounds very similar. It was against a head of state the United States did not recognize, Manuel Noriega. He was under indictment for drug smuggling into the United States, and the United States sent in a military mission to apprehend him and bring him to justice inside the United States. So it's very similar. But the UN General Assembly passed a resolution condemning the operation as a violation of the UN Charter. So for the U.S. ambassador to just stand there and say, this is just like Panama inside the UN law on this is that they passed a resolution saying, quote, that the General Assembly strongly deplores the intervention in Panama by the armed forces of the United States of America, which constitutes a flagrant violation of international law, end quote. And voting for that were U.S. allies, including Spain. France also agreed that the U.S. was in violation of the UN Charter in the UN Security Council meeting. But at the time, and this is where I'm going to leave it, is the United States most definitely made arguments in law, legal principles that are limiting principles. President George W. Bush presented to the American public on the date of the operation and said, we are invited by the democratically elected legitimate government. And if we're there by invitation, in a sense, that's an exception to the use of force. We're not using force against Panama. We're using force by invitation of Panama. That's a good there's a good argument there. Second, President Bush said that the Panamanian National Assembly had declared a state of war against the United States. So we didn't start it, they started it, and we're acting in self-defense. Third, the president said, the Secretary of State, James Baker, said, and the very esteemed as well U.S. Ambassador to the UN, Thomas Pickering, all said that the United States was acting in Panama because of the imminent risk to U.S. civilians there, and that it had come right on the heels of, according to the United States, armed forces under Noriega's command having killed one unarmed American service member, wounded another, and arrested and brutally beat a third American service member, and then brutally interrogated his wife, threatening her with sexual abuse. And that Secretary of State James Baker said in a press conference that we had U.S. intelligence information that Noriega was planning a commando-like attack against American citizens inside Panama. We had to act in self-defense against an imminent attack. That is the language of international law. And I think that's where we're in a very different place today, in which there's not even not even an attempted legal justification. And then I would place that one in the context of Greenland. That if you were tracking very closely when I read the UN Charter provision, it says not just the use of force, but the threat of use of force. It really is prohibited to threaten another state with illegal use of force. The Greenland operation obviously blows that out of the water. I do not even know what a legal justification possibly could be for that. I've articulated a couple for the Venezuela operation, but I cannot even imagine one for the Greenland one. Yet we had the United States' official position be threatening to use military force to take over Greenland if the Denmark did not succumb to U.S. foreign policy demands. And I think that's, to me, of a piece in a sense with not even offering a legal justification for Venezuela. And I don't think there's a good one, but at least it would be helpful, and an important value for the international legal community that we're still operating by the rules of the road.
Thank you, Ryan. That was deep and detailed. Thank you. Jeff, would you like to go next?
Yeah, so first off, I want to echo the gratitude for being invited. Thanks to Butch for thinking to put this together. It's an honor to be on the discussion with Ryan, who I have such great respect for and rely on so frequently for his insights. And his presentation was definitely loaded with a lot of food for thought. I will say that I struggle a little bit with the kind of immunity from the Article 2.4 prohibition. I understand the theory that you're in international waters and ostensibly attacking stateless vessels, although we don't really know for sure that they're stateless because we don't have direct information on who's being attacked. But I think that there is something more fundamental about the Charter and the relationship of Article 2.4 and Article 51, which is the kind of default position that states are not supposed to resort to combat power to advance a national security interest unless and until certain thresholds are crossed. And it seems pretty broad to suggest that just because you're in international waters against a stateless entity, there's no constraint on kind of skipping over a law enforcement response mechanism and going right to armed conflict and killing people as a measure of first resort. Now, part of this may implicate the relationship between the legality of using force and the authority to use force under international law and whether something qualifies as an armed conflict. And we're all taught that we're supposed to keep those two issues separate. And that makes perfect sense when we're talking about the invalidity of a state arguing that they don't have to follow the rules of war because the enemy they're fighting is an illegal enemy. But it might not make as much sense from the other direction, that you are initiating hostilities and therefore you're automatically allowed to invoke the use of force authority derived inherently from the principle of military necessity and the law of armed conflict. One thing I think I think Ryan and I would agree on is that the theory that has been advanced in the rhetoric of the administration that tens of thousands of Americans are killed every year from illegal narcotics, and therefore the importation of legal narcotics qualifies as an armed attack, justifying the invocation of the inherent right of self-defense, overlooks a critical element of armed attack, which is there has to be some intent or motive to inflict that harm. That certainly seems to be the traditional notion of what qualifies as an actual or imminent armed attack. And it's not just the harm itself that manifests an armed attack. It's the goal of inflicting that harm. And you'd have to be a pretty foolish narco syndicate to try and deliberately kill your customers. So I think there's something deeply problematic about this constant emphasis on the loss of life produced by illegal narcotics. Now that doesn't even account for the question of whether the narcotics are really coming from this group and how distant they are from the United States and the agency of individuals that are consuming the narcotics. And I think that illegal narcotics are a scourge. Like Professor Bracknell, I was a military prosecutor. I put people in jail for distributing narcotics. And I think it's tragic that so many Americans suffer the consequence of that. But all of that together, in my view, doesn't arise to the level of a self-defense triggering justification, unless you can show that there's some intent to inflict the harm that's being inflicted. With regard to the boat strikes, then we get to another complicated issue, and that is when is a state justified in asserting that it's engaging in an armed conflict? And I think part of the challenge here is that when we're talking about an armed conflict against a non-state group, the law, international law, never really contemplated kind of a jus ad bellum, if you will, for non-international armed conflict. I think when Common Article 3 was adopted, the assumption was states are going to want to avoid asserting they're in an armed conflict against a non-state threat because those threats were perceived primarily as internal threats. And in fact, the history of non-international armed conflict is ripe with examples of states facing something internally that by any objective measure arises to the level of an organized armed group engaging in hostilities, but the state refuses to acknowledge that. They insist that they're engaging in law enforcement because even though Common Article 3 to the four Geneva Conventions, which is the origin of this notion of non-international armed conflict, explicitly says that acknowledging the existence or the application of this provision in no way impacts the legitimacy of the non-state group. I think politically it's always viewed that way. I know that was the instinct of the US government after 9/11. When I first got to the Pentagon and went to my first meeting of the Law of War Working Group and was perplexed why we were so averse to acknowledging the applicability of Common Article 3 to Al-Qaeda. And the answer was because the politicians think that it suggests some type of legitimacy or credibility for the non-state group. And we know that's wrong legally. But politically, you know, I can remember being in Turkey 10 years ago, and I was talking to one of my Turkish academic colleagues, and there had been a Turkish Air Force F-16 attack against a Kurdish base camp. And I said to my friend, Feridun, isn't that an indication of armed conflict? He said, no, that's just a law enforcement operation. They're just terrorists. Because there's this aversion to acknowledging the existence of armed conflict when the threat is internal. And then we have kind of an irony that when we started to acknowledge the ability to engage in a non-international armed conflict outside your territory, a transnational armed conflict, if you will, so an armed conflict with an organized non-state group that extends beyond your territory or is primarily outside your territory, then there's an incentive to characterize the situation as an armed conflict because it accrues for the government the ability to use the extraordinary power of war. And that line is something I think that people really need to understand. When a state says it's engaging in an armed conflict, it opens up an authorities that otherwise would be impermissible in a law enforcement response paradigm. You can kill people as a measure of first resort. When I was a soldier, when Butch was a Marine, we weren't trained to use tasers. We weren't law enforcement officers. We didn't have an obligation to use minimal necessary force. I mean, this is the essence of military necessity in an armed conflict. Using the amount of force that's not otherwise prohibited, that's necessary to bring about the prompt submission of your enemy as a collective entity. You can detain people without trial, without charge, indefinitely for the duration of hostilities. You can make those decisions not based on actual threat, but based on status. Targeting and detention are status-based. I make a determination you're a member of the enemy armed group, and I can use this level of power. And in theory, you can theoretically use an extraordinary criminal tribunal. Instead of bringing individuals before a normal Article 3 court, you can convene a military tribunal and allege that their conduct violates the laws and customs of war and try them in front of that tribunal. And we've seen this play out for decades now in the euphemism of the war on terror. So when the government claims that this entity, Tren de la Agua, is engaged in an armed attack against the United States and they're an organized armed group, therefore we can kind of cross that line from a law enforcement response mechanism to an armed conflict mechanism, I think we have to ask, when is that legitimate? Now, traditionally, we say for a non-international armed conflict to exist, there has to be sustained hostilities between two organized armed groups. So the government says, well, Tren del Agua has kind of a command and control mechanism, so it's got military type organization. They do use violence to advance their criminal agenda. There's no question about that. And now we're using combat power against them, so we have sustained hostilities. There's something in my mind that's a bit perverse about that. If a government wants to invoke the power of war by starting a war and then saying that proves we're in a war, then what stops it from using that level of force against any criminal syndicate? And this is why I think the whole theory that this is an armed conflict is flawed from inception. This is international law enforcement, and it's been an effective tool we've used against the problem for decades. Now, some commentators argue it hasn't been effective, that the law enforcement response mechanism has been flawed. Well, that may very well be true, but that in and of itself, I don't think justifies jumping right into an armed conflict paradigm and just starting to kill people as a measure of first resort. Let me drop a footnote here. You've all probably heard a lot of criticism of extrajudicial killing, right? I always find that term a little bit misleading, because if you are legitimately in an armed conflict, most killing is extrajudicial killing because it's legally justified in that context. So the idea that a government would engage in extrajudicial killing is not in and of itself an indication of illegality or invalidity. I think the much more fundamental question is, do you have a legitimate claim to invoke the power of war, to claim you are in an armed conflict, and thereby legally justify that extrajudicial killing? And so when I'm asked questions of is attacking boats, are boats a legitimate target, I struggle with that because they can only be a legitimate target if you are legitimately in an armed conflict. And you're generating an armed conflict through your overzealous or overbroad assertion of combat power to begin with. I think one of the most interesting episodes in this whole equation of these boat strikes was the now infamous double tap, right? And I was asked many times, do you think that was a war crime? And my response initially was, I struggle with even characterizing it as a war crime because I don't think it's an armed conflict to begin with. But if we assume it's an armed conflict, then we get to secondary target determination levels. What makes a drug boat a military objective? What is it doing that is offering an effective contribution to the enemy military action whose total or partial destruction in the circumstances ruling at the time will offer us a definite military advantage? Where's that analysis? The government says the people in these boats are enemy belligerents. They call them unlawful combatants. I think legally that's oxymoronic. If you're a combatant, you are lawful. I think really what they're referring to is what's in the Military Commission Act now after it's been amended, unprivileged belligerents. You're a belligerent because you're a member of the enemy armed group, and you're unprivileged because you're not fighting on behalf of a state, meeting the qualification to be a combatant. But whether we call them unlawful combatants or unprivileged belligerents, the theory is because you're an enemy fighter, I can kill you as a measure of first resort. What's the threat identification criteria that supports that conclusion? How do we know who members of the enemy armed group are? Who's making that determination? I started my career as a tactical intelligence officer. That was my job, was to learn the enemy threat identification criteria and help commanders identify when someone fit within that criteria. Nobody knows what that is. I mean, Ryan's talking about the legal memorandum of the legality of the military operation, but what are the judgments on how do we decide who the enemy is? And then on the attack on that, the survivors of the boat, very interesting. Most commentators immediately assumed that the attack was directed against the survivors. I think Ryan and Butch and I would all agree that if there are shipwreck survivors after an initial attack and there's an order to kill them, that order is on its face illegal. But I never assumed that was the order. How do we know that the second attack was directed against the survivors and not directed against the remnants of the first attack, with knowledge that it would kill the survivors? That's a very different legal dilemma. And here's why. People may assume, well, if you're attacking the remnants of the boat and you know there are survivors there, you have to do a proportionality analysis. That's not accurate. Proportionality in the conduct of hostilities protects civilians. And because the government has said they're not civilians, they're unlawful combatants, they are not, as a matter of law, protected by the proportionality rule when I'm deciding whether to conduct an attack on a proximate military objective. So the initial question is, were the remnants of the boat, after you hit it once, a military objective? And if so, why? What was the definite military advantage you were going to derive from a second strike? It is interesting, and I think very positive, that the Law of War Manual, the DoD Law of War Manual, acknowledges this. It acknowledges that if you're conducting an attack on a legitimate military objective, and you know that there are enemy wounded and sick, or by inference shipwrecked, proximate to that military objective, they are not protected by proportionality. But the manual also says we should apply, by analogy, if you will, the doctrine of precautions. You should endeavor to avoid or mitigate the risk to those wounded, sick, or shipwrecked enemy combatants. And I actually have to say, when I went and looked at the provision, I didn't know that was in there. Maybe Ryan knows the background of how that got in there. I do know that I, along with a student, I wrote an article about this about a decade ago, the dilemma of military medical personnel and wounded and sick in relation to the conduct of hostilities. And that, my argument was, extending the proportionality rule to them is illogical. And here's why. If I'm in a battle with an enemy armed force, a state armed force, I'm in a naval battle. So our Navy ships are battling, pick it, Chinese, Russian naval vessels. And our naval ship launches an attack on an enemy naval ship, and they see enemy sailors get blown overboard. Those sailors are now shipwrecked. Our commander is not going to do a proportionality analysis before he launches the next salvo. That would be illogical. What's more logical is to ask the commander to at least consider whether there are feasible ways to protect them from the consequences of the second attack. So for me, one of the hardest questions about that second attack wasn't why you were attacking it, although I think that's hard. It's why you didn't do something to rescue the shipwrecked members before you launched the attack, if there was really a 40-minute gap, even if it was nothing more than dropping a raft in the water so they could swim away from the remnants and save themselves. That's what the DoD Law of War Manual actually requires. And I think it's a good rule. On the attack into Venezuela to get Maduro, to me, the most fascinating part of this dialogue, other than the point that Ryan makes, which is we never really asserted an international legal basis, the rhetoric has all been, it was a law enforcement operation. Now, I think it's very important that we recognize that there's a difference between a law enforcement objective and a law enforcement operation. You can have a military operation with a law enforcement objective. But just because you have a law enforcement objective doesn't mean the entire operation is a law enforcement operation. It defies logic to argue that the operation that was conducted to capture Maduro was not an armed conflict. There was no consent. We used combat power. We engaged in condition setting activities in order to set the conditions for the non-consensual combat entry. We engaged in hostilities with Venezuelan forces and arguably Cuban forces. We captured the target. We got him out. Okay, there was a law enforcement goal or objective. That was an international armed conflict by any objective standard. And just saying you had a law enforcement objective doesn't change that. And I think one of the most fascinating parts of this is the analogy to Panama. That's my background. Okay? What you're looking at there is the Pacific entrance to the Panama Canal. And I want to bring this up because it goes to the invalidity of the analogy. I'm trying to get there. So that piece over my shoulder was Fort Amador. Okay? Fort Amador was where General Noriega had one of his offices. It's also where the United States Navy had its offices, and there was a golf course that ran down the middle of that base. On one side of the golf course was Panamanian Army infantry barracks. On the other side of the fairway were American military houses with families. I was there. I got to Panama at the end of 1984. I was there through the middle of 1988 as an intelligence officer, not as a JAG officer. I was there when we were allies with the Panamanian Army. I met General Noriega in the hills outside of the border with Costa Rica when we were training. I was there when the relationship collapsed, when the indictment against him was announced or unsealed in 1987. March of 1987. I'll never forget it because I was thrown in jail for a day for no reason. I was just harassed by the Panamanians. The reason I bring this up is that the argument that what we did in Venezuela was identical or analogous to what we did in Panama defies all logic for a number of reasons. We could have arrested Noriega for a 2-year period. He was under indictment from March of 1987 till December of 1989. He worked on the same base as American military units. There were 2 coup attempts in that period of time, one in the spring of 1987 and one in early 1989, where we had the opportunity, with very minimal intervention, to make those coup attempts successful and get Noriega, and President Bush chose not to do it. It wasn't until, as Ryan says, a line had been crossed. Now, why was that so significant? I've had people say to me, well, look, if one American service member is killed at a roadblock, by the way, the irony of that is his name was Paz, Spanish for peace, Lieutenant Paz. If one American service member is killed at a roadblock, that doesn't justify an invasion. What people don't understand is there had been a standoff between the Panamanian Army and the American military for nearly 2 years, where there had never been any serious act of violence. There'd been low-level harassment, like what I experienced. It happened quite frequently, because technically you were not allowed to go off the base in your uniform. So you'd be driving home to your apartment in Panama City, and a Panamanian cop would pull you over and arrest you for wearing your uniform. And then they'd argue about it and they'd let you out in a couple of hours. No one had been seriously hurt. Something changed that night over that weekend. And I think President Bush was justified in asserting a right of defense of nationals when he launched that invasion. And it had to be big and it had to be swift because there was no way to evacuate 30,000 Americans from Panama who were living there. And just imagine you are a family living in a house across a Gulf fairway from what is ostensibly a violent army enemy. You can't take the chance of a slow walk or an incremental action to eliminate that risk. There was no self-defense justification for Maduro, in my view. Nothing analogous. The other thing that's ironic is Ryan is correct that the government's position was that we were invited in. We brought the elected president, Endara, the election that Noriega had nullified. We brought him to Albrook Air Force Base. We found a Panamanian Supreme Court justice. They swore him in, and he immediately said, I need your help getting rid of Noriega. And we said, well, that's coincidental because we have a Ranger battalion flying over your country right at this very moment. So it worked out pretty well. But there was never an argument that the law enforcement objective of apprehending Noriega meant that it wasn't an armed conflict. The government took the position from the very beginning that it was an armed conflict. The only debate was whether it was international or non-international. And the executive branch took the position that Noriega was not entitled as a matter of law to prisoner of war status because we had been invited into Panama, and therefore it was not an interstate conflict. The federal district court judge that presided over Noriega's case rejected that argument and just looked at Article 2 of the Geneva Convention and the commentary. And to paraphrase, he said the executive branch can call what happened in Panama on the night of December 19th anything it wants. But as a matter of international law, it was an international armed conflict. And General Noriega was a prisoner of war for the entire period of his incarceration, even though there was no army to be a part of anymore. It was disbanded. So the government never pretended that because there was a law enforcement objective, you didn't have to acknowledge the applicability of the rules of war. And isn't it ironic that when General Kane got up at that press conference in Mar-a-Lago after the operation, all of his terminology was law of war terminology. We identified military objectives, we used precise engagement, we implemented feasible precautions. So I think for the military, it was never in doubt that they're going to follow the laws of armed conflict to conduct the operation. The issue then becomes what's the impact on Maduro's status? And I don't really think that that should be much of a concern because he can be a prisoner of war and still be held accountable for the charges he's under indictment for. I think it goes more to Ryan's point that the government doesn't want to take a position that this was an armed conflict. Because it was an armed conflict, then there has to be some legal justification under international law for the intervention. Instead, it's this sleight of hand that it was just a law enforcement operation, and therefore we don't have to answer those questions that Ryan brings up. So my greatest frustration of all of this comes more from I'm sorry, I don't remember your first name, but the co-host who introduced us and said a range of legal issues, political issues, and I was waiting for you to say moral issues, right? Because when the United States government orders an American service member into combat, they are ordering that person to kill another human being. My strong belief is that before we order Americans in uniform to engage in that type of activity, they have an entitlement to moral clarity. And I think moral clarity derives from legal clarity. And the less legal clarity you have for an operation, the more moral hazard you create for the forces. And I think that's unfortunate. I think our personnel are entitled to moral clarity. I don't underestimate the drug problem. I'm all for enhancing the role of the military in international criminal operations against these actors. But simply calling a criminal threat an armed conflict has profound human consequences, not only for the people at the end of the missile, but I think also for the men and women who have to pull that trigger. And I think that's something that we often forget. Thank you.
Oh, that's beautifully put, Jeff. Thank you. We have a few minutes for questions, and I think we need to take the questions quickly. So if you could just, if you have a question you'd like to ask, please raise your hand, and
You can repeat it.
and I'll repeat it if I can't reach you with the microphone. I think Professor Bracknell wanted to ask a question.
So my question really is for Ryan. Ryan, can you address, there's been a lot of information out from the administration about this concept of DTOs, designated terrorist organizations. I know we have a statutory term of FTOs, foreign terrorist organizations, which carry some consequence. Can you explain the distinction and whether DTOs is a thing, and if it is, how does it affect the ability to conduct targeting?
Right. So as you say, there's a statutory authorization for FTOs, foreign terrorist organizations, and that statutory authority would not trigger any form of use of force to enforce it. The statutory authority of designating some entity as a foreign terrorist organization primarily has a lot of financial implications in the sense that the members' assets can be frozen around the world, and it has domestic U.S. criminal law implications. Material support for an FTO is a crime, but nothing that would justify any military force against them. The DTOs is sounds like it's a somewhat of an amorphous executive-only determination. We don't even know which organizations are on there because it's a classified list. They're apparently, and the Office of Legal Counsel opinion that that is not public, that provides legal justification for the boat strikes, apparently says yes, if some entity is designated as a DTO, that's sufficient. Second, it says that it doesn't even have to be designated as a DTO or an FTO, that the list is even broader than that, which has all sorts of other implications to it in the sense of like, how are people even supposed to be on notice that they could be killed on the, while transiting drugs and the rest. And so it stays there. And then one other piece that I thought I'd just mention on it is, it sounds intuitive that if some entity is designated as a terrorist organization, then the United States can use lethal force against them. But that begs the real question, which is A, not as a matter of U.S. domestic law, and B, as a matter of international law. I agree with everything that Jeff said. There's no way in which this triggers the law of armed conflict or an law of self-defense, insofar as all we're talking about is the scourge of drugs coming into the United States. And that's the designation. The designation is apparently for drug cartels specifically.
I think we might have time for one or two more questions. Yes. Well, I'll repeat your question.
So I know this might be more related to Venezuelan law, I guess. It's kind of in the dark with like now the U.S. kind of having a presence or not. And before all this, there was a president-elect of Edmundo Gonzalez, but there's also talks of whether Venezuela enters an election, with it being maybe a transitory period. I mean, what are kind of the next steps, essentially? Because I feel like there's a lot of different paths now that the U.S. is kind of forced in. And do we go by, like, what kind of the Venezuelan constitution says of holding an election? I think it's like 30 days after, or you go with Edmundo, like, what are the...
So the question is about the future of Venezuela. We're in a moment where there seem to be different paths that are forward for the Venezuelan government, whether it's holding elections, whether it's moving forward in the current course. Do you have any insights on what might lie in store for Venezuela?
Jeff, unless you'd like to go.
I defer to you.
I mean, yeah, it's like anybody's guess.
Yeah.
And it's also like anybody's guess if you read what comes out of President Trump versus Secretary Rubio. Those don't seem to align. So the messaging is quite vast. But I'll just say a couple thoughts in terms of international law and what it might have to say, which is one, I've written about this with Mike Schmidt and Tess Bridgman. The international armed conflict that is triggered from the U.S. operation inside Venezuela is continuing. That has not ceased. Partly it's not ceased because of the military operations against the quarantine and the continuing threat of use of force by the United States and the military posture that we're in. So that's one part. Second is, it is important to know, just in terms of the international legal violations here, I think it's really important to know, international law has a separate body of rules about the prohibition on non-intervention or the prohibition on non-interference. To use coercion against another country to dictate to them how they should run their politics is a violation of international law separately. And so is regime change. And so the violation to me is not specific to the absolute resolve operation. It's a continuing question. And it is interesting, once again, there's different places to see what's going on from inside the administration. But the Office of Legal Counsel opinion, interestingly, says it is an international armed conflict against Venezuela, even though the U.S. ambassador to the UN said we're not at war with Venezuela. So it's like, how do you square those two? The I guess the administration in other ways has been consistent on the idea that this was not regime change. The OLC opinion says, well, obviously this is regime change, like, because it's inevitable. You're taking away the putative head of state. So I think we're in a treacherous period in which my concern is that it's purely power politics that's driving this. So what's in store for Venezuela really does seem to depend on power politics. It's not being governed by these kind of standalone, it's not standalone, but baseline international legal rule books. So difficult to know what comes next.
Actually, thank you. That leads right into the question I wanted to ask is, Ryan, I would appreciate your opinion on the trajectory of the development of international law. And I look back and I wonder, right after the bombing in Kosovo, when Kofi Annan opined that sometimes violation of law is not, or these acts are not legal, but they're legitimate. And I wonder if that was the beginning of the erosion of public international law, and now we are just seeing it thrown by the wayside. And I wonder also about the fact that it was U.S. action in Kosovo that created that legitimacy exception, and now we have U.S. action again, which might result in the total diminution of international law. I wonder what your thoughts are.
I think I very much agree with that, and I think it is great and important to place it in historical perspective, because the United States, under Democratic and Republican administrations, has played fast and loose with international legal rules. The Clinton administration never said that the Kosovo intervention was legal. They said it was justified. And I think that happened again with the strikes in Syria. So first, Obama said that he wanted to hit Syria for Assad's use of chemical weapons, and he didn't end up doing it, but he certainly threatened it. And he said it was his policy option. And the big question was, how on earth inside the Obama administration are the lawyers justifying that? Because it's not self-defense, it's not Security Council authorized. Then President Trump did it twice. And there, I think as well, something happened where there's a large body of the international community that thought, nah, legitimate yet illegal. Like when I presented at the UN on issues around Syria, I was told by somebody, a large part of the UN members think that it's absolute lawlessness in Syria. The fact that something would be done to stop Assad from using chemical weapons, they're not so tied up and worried about that. But there's the erosion, as you describe it. There's the erosion. It's things that are taken as legitimate, yet totally illegal. And I do think that that's partly what's happened with Maduro. Maduro does not have many friends around the world. There are many states that would fail to recognize him as legitimate. And I do think that's part of the muted response at the international level. That's one part of it. The second part is, I think, countries being concerned about the way in which the United States is not playing by the normal rules, and they're trying to land the situation in Ukraine. So they're also kind of giving a little bit of a pass here than they otherwise would. That said, at the UN Security Council, France spoke out against the U.S. operation in Venezuela. Denmark spoke out against the U.S. operation. Spain spoke out against the U.S. operation. These are our natural allies. And then one other one that I think doesn't receive enough attention is the non-aligned movement. So the non-aligned movement, an individual state member speaks out, but they speak on behalf of 120 plus states. They condemned, in probably the strongest terms at the UN Security Council, the Operation Absolute Resolve to abduct Maduro. So I think there's a struggle going on right now to preserve some basis for the international legal order, because I do think we're now in a new stage in which we really are kind of a different frontier of just absence of legal justifications, and the only justifications that are in fact explicitly stated are just realpolitik justifications about energy markets and things like that.
But can I just jump in? I think, Ryan, would you agree that especially with the Kosovo situation, it felt like a struggle. They tried to figure out some legal justification. I remember Madeleine Albright's bootstrapping argument. If you pile up all the Security Council resolutions, they don't explicitly authorize this, and we have to have a regional organization in unanimous support of the operation. for me, the difference is now we're at a point where it's unilateral and there seems to be no concern whatsoever that it's, as you say, it's purely an exercise of power. If it serves what is perceived as by the president as a national security interest, then we do it. And you brought up a couple of times, we don't have time to get into the domestic piece, but that's problematic as well, because now not only do we have an administration that seems not even remotely constrained by international law. They unlike prior examples where you can take the case of Syria and the consequence of not action is so grave. And I think with Clinton, with the immediate memory of his failure to intervene more aggressively in Rwanda, he wasn't going to be responsible for that again. Now you have a completely different attitude towards it. So the way I would say is that Clinton, Obama, they were inclined to push the envelope. That's different than just shredding it. And what we have now is it's being shredded and with a claim of unilateral authority to make the decision of when these are in the national interest with no apparent concern of soliciting congressional support. You put those two together and it's just wide open. And then you have a president threatening to invade Greenland.
Well, if there's one thing we can all agree on, it's we've entered a new chapter for U.S. foreign relations and international law. Sadly, we're out of time. I want to thank our panelists for their excellent remarks. It's been such a stimulating conversation. Thank you both. Thanks everyone for coming and supporting this event.